goal of an entrepreneur should be to maximize the company's chances of success. And in order to do that, it's important to, in an employment context, make sure that your liabilities to the employee and the employees due to the company are clearly set out. In particular, what you have to pay the employee if they're terminated. Everyone in a startup should sign an employment agreement. The founder, the president, everybody else. If they don't have an employment agreement and you have to let them go, and there's always a lot of churn among employees and management in a startup, then you don't want a court making up what they think you owe them for terminating them. It's almost always far more generous than everyone would agree is fair at the front end in a written agreement. The second thing you're going to want, and this is typical in startups, is non-competes. In Canada, non-competition agreements are very difficult to enforce. And your only chances to enforce them, though there's been some cases that have upheld them relatively recently, so 10 years ago it was bleak trying to enforce a non-competition agreement. They appear more enforceable now. But the key is to, if you're going to make it enforceable, is to do two things. One, keep the non-competition provision as narrow as possible, so it includes as close to the specific business and responsibilities within that business that the person is occupying. Don't have it be big and general, because courts strike non-competition agreements down if they think it's going to interfere with the person's ability to make a living. So keep it as narrow as possible. Plan on it being relatively short-term protection, 6 months, unlikely to be enforceable if it's longer than a year. Think carefully about what the geographic restriction is. If you've got a business that's really only going to run in Alberta, or really only going to run in Calgary, or really only going to run in one specific area, then confine it to that. Don't try and make it worldwide. The second thing to do is, if the person that you're trying to get a non-compete from is getting equity, tie the non-compete to the equity. That tends to be more enforceable if it's part of what the person is paying to get shares or options in the company, rather than part of their employment agreement. You're going to want non-solicitation provisions that prevent them from either hiring away your employees or hiring away or stealing your customers or clients or business partners. Non-solicitations tend to be much more enforceable. You can make them much more robust in an employment agreement. And then you're going to want provisions restricting their ability to disclose confidential information, called trade secrets. And so you're going to want a standard confidentiality agreement that is that can be pretty general. They tend to be reasonably enforceable unless they're worded so broadly that, once again, they'd actually interfere with the person's ability to get any kind of job at all in their chosen area.